The next case is Stoicoiu, if I'm saying it right, for Stow-Munroe Falls City School District, Board of Education. Each party will have 15 minutes to present their argument. Council, how long would you like to reserve for rebuttal?
5 minutes, please.
Very good, we'll note 5 minutes. You'll be looking at that top clock for you, at this top circle. When it gets to 5, that's your rebuttal time. I'll try to let you know about a minute left. And then council, you're that middle time. I'll do the same for you, try to let you know about a minute left when we get to that point. The arguments are being recorded, so when you come to the podium, please introduce yourself for the record. Please make sure you stay behind the podium because we're visually recording you, and then speak loud enough so the audio can pick you up as well. I don't know in this case we have any children, minors, or victims in this case to be concerned about, but if we do, please use initials rather than full names. With that, the court read your brief is ready to proceed whenever you.
Good morning, and please the court, Jack Morrison, on behalf of the appellant, Mrs. Stoicoiu. The single issue in this case is whether or not my client provided evidence that the proper reason for her termination was contextual. And the simple answer to that is yes. The standard of review in this matter is a Stow-Munroe review. Here, all facts and evidence and inferences must be considered most favorably to my client on the defendant's summary judgment. So the question is, what facts are in evidence that support my client's argument that her termination was contextual? Here the evidence is both sworn testimony as well as documents in the record. There are at least 7 or 8 separate facts that we rely on to overcome the proper reason for my client's termination.
Attorney Morrison, I have to ask a question.
Yeah.
It seems like this law is not addressed, or the spotting law isn't addressed anywhere with the trial court or with the parties, but can a contract employee bring a wrongful termination act? Don't we have case law that you have to be an at-will employee to bring a wrongful termination act? And then also, don't we have case law that non-renewal of a contract is not an adverse employment event for a contract employee?
In this thing, even if you're a contract employee, if you are retaliated against under the whistleblower statute, you have the protection of the whistleblower statute. Secondly, relative to the issue of the non-renewal, the law is clear in Ohio, and we cited to it in our brief, that non-renewal of a contract is considered an adverse employment action.
But isn't that only in the context of a discrimination claim, not with a whistleblower claim?
As I read the case law, I did not see that distinction, Your Honor. So the facts and evidence are, number one, the board president openly criticized my client for reporting the illegal expenditure to the state auditor. That is in both testimony of my client, which is part of the record. Number 2, the illegal payroll scheme that had been developed by the superintendent had started 4 years before my client ever became the treasurer. That is documented both in testimony and the illegal payroll record. Number 3, my client was not responsible for managing payroll, approving payroll. Her only job was to receive payroll reports from human resources and make sure that the report of human resources is the amount that was actually paid. Here, the superintendent had his own payroll. He reported the false payroll. My client was unaware of the fraudulent scheme. That is put by testimony and documents in the record. Number 4,
So this judge made a finding that your client wasn't a whistleblower and there's not a causal connection. Are you saying she improperly weighed that?
I believe that what the court found is that there was a question of fact or whether or not my client was a whistleblower that had yet to be determined. She went on to say, however, since they provided a business reason, we had the burden to show it was contextual, which is essentially a causation issue. Well, our argument is we have done that. The first item is that the illegal expenditures of the payroll were actually a brainchild of the superintendent to funnel money to his administrative assistant. My client had no involvement in the superintendent's office or the payroll to his administrative assistant. Number 5, some of the illegal expenditures were actually gifts received by board members, including the board president, who was upset with my client for reporting it to the state auditor. Those board members retained those illegal gifts until the state auditor required them to repay those back to the district. Number 6, during the 8 years that my client was with the district, he never had a single negative performance review until after he reported the theft and misuse of money to the state auditor. Then they called her in and gave her a negative review.
So you're saying that your client presented enough evidence to make a material issue that the cause for not renewing is a pretext?
Yes, Your Honor, and simply stated, under the statute, a whistleblower has to show, 1, that they reported illegal conduct, 2, that there was adverse action, and 3, that they had damages. Once she has met that prima facie case, then the defendant can offer a business reason for the termination. Then the burden shifts back to the employee to say, no, that legitimate reason is not why you did it. It was contextual, and here's the evidence to support that. That is a question of fact if the employee can present evidence that a reasonable person might conclude is a real reason she was terminated.
About 1 minute in your initial time, Attorney Morrison.
The 7th item is that following the public disclosure of the fraud administrative assistant and superintendent were never disciplined in any way. In fact, the administrative assistant got a raise. The board members who had received illegal gifts were never disciplined in any regard. And finally, number 8, my plant was terminated even though she is the one that uncovered the fraud involving the superintendent, the administrative assistant, and the board members who have received illegal gifts. The defendant would have you believe that none of that related to the reason my plant was terminated. I do not believe that a reasonable person could not consider those in fact and conclude that the board offered an illegitimate reason for termination and terminated my client because we reported the illegal conduct to the state auditor. Thank you.
Thank you.
May it please the court. Good morning, your honors, counsel. My name is Stephanie Oliveira-Mitica. I represent the appellee in this matter, the Stow-Munroe City School District Board of Education. The board respectfully requests that this court affirm the order and judgment of the Summit County Court of Common Pleas regarding the board's motion for summary judgment and find that the trial court did not err with regard to either of the assignments of errors raised by Ms. Stoicoiu today. Despite being given the second opportunity, the fact remains that Ms. Stoicoiu is not a whistleblower. The board articulated a legitimate, non-retaliatory basis for their employment decision and non-renewing her employment contract, and Ms. Stoicoiu has failed to produce any evidence demonstrating that that reason was pretextual.
Counsel, one of the arguments that the appellant seems to be making is that basically that the trial court cherry-picked the facts because it didn't consider all the facts, and therefore that there were genuine issues in material fact.
I would disagree, Your Honor. The trial court, I think, took its time. Obviously, this court had previously remanded this case to look at the pretext argument, and I think that the court was diligent in that regard. It considered both sides' arguments. It analyzed pretext as well as a prima facie case. As Mr. Morrison alluded to here, the first step in a whistleblower claim such as this is Ms. Stoicoiu has to establish a prima facie case, and she failed to do so. She has to show that that she engaged in protected activity, that there was an adverse employment action, and then the causal connection.
But the court never did determine that she hadn't made a prima facie case, right?
The court determined that she did not satisfy that standard, correct, Your Honor. And in
What
doing so,
standard? Which standard?
the court found that that Ms. Stoicoiu failed to establish a causal connection between her between her alleged protected activity and the employment decision taken by the board.
Well, I'm confused, so I'll tell you why. Because before we get the pretext, you have to have a prima facie case. So we sent it back and told the court to look at pretext. Why would we do that if there was not a prima facie case?
So previously, before the 9th District, there were 2 assignments of error. The initial assignment of error was related to the motion to strike that was filed by Ms. Stoicoiu related to the board's reply brief. There was an argument made that there was new arguments raised in the reply brief that were not otherwise made in the initial motion for summary judgment. So the 9th District Court of Appeals remanded based solely on that assignment of error. So there was no substantive decision on pretext at the initial through the initial appellate review. So it was remanded strictly on the motion to strike the first assignment of error.
Okay, I have another question for you. Because I'm not sure what's in the record in regard to this, but it appears at least that there might be an argument that some of the expenditures that were approved by the appellant, that that were approved by the board were not ones that were reviewed by the appellant, but were reviewed by the prior treasurer. Is there evidence of that?
I don't, Your Honor. What I do know is that Ms. Stoicoiu was, she's been in the treasurer's office generally for several years. She received her treasurer's contract in 2017, and the decision to non-renew her occurred in February of 2019.
So wouldn't that be relevant in regard to whether the prior treasurer was doing the same procedure and approving things that were illegal also?
Well, I mean, there may have been issues that occurred prior to her taking the treasurer position, but our position is that there were also performance issues and expenditures that occurred while she was treasurer for the district.
I have an Ohio State Supreme Court case, Haynes versus Zoological Society, that says at-will employees are the only ones that can bring actions under whistleblower statutes 4113.52. Nobody at the trial level addressed that in the opinion or in arguments, and how do we address that? That's the case.
Certainly, if that's the case and that's the opinion of the court, then we would certainly respect that opinion.
I mean, do we send it back for you to have the opportunity to brief it and argue it to the trial court? Do we do something about briefing here?
We believe that a decision can be made on the merits based on the current record and the current decision of the trial court. We believe that that decision should be affirmed. As it relates to the prima facie case, the court found there was no causal connection, and even if there was, it did go on to evaluate both whether the board was able to articulate a non-retaliatory reason, which it did, and then once the burden shifted back to Ms. Stoicoiu, the court also found that there was no pretext. And really,
So I want to go back to Judge Lansinger's question. I know it's a little awkward because I'm thinking maybe he's raised it, right? So if you didn't raise it, what does that mean? You never argued that they didn't have a cause of action. You never moved to dismiss the complaint or anything, right?
I believe there was an initial motion to dismiss.
But it wasn't on the basis that this cause of action couldn't even exist because she was an at-will employee.
I believe that's correct, Your Honor.
Is a person under a continuing contract an at-will employee?
No, Your Honor. So I wanted to touch briefly on really the critical timeline of events here, because I think they hit the heart of both the prima facie case and this issue of the causal connection. So again, the initial financial irregularities that were kind of identified here were not identified by Ms. Stoicoiu. They were identified kind of by a third-party community member. Ms. Stoicoiu took that information to the board, and they immediately requested that those anomalies be investigated. She did that, and in the process uncovered some other financial anomalies that previously, at least in part, were reviewed and submitted to the board by her and her office. To be clear, these findings, these kind of subsequent findings that were made, only came to light because the board was the one who gave her the directive to continue investigating this matter.
But she nonetheless brought up the issue again.
Because there was a phone call received by the treasurer's office, actually not even her, I think it was an assistant that kind of fielded that initial call from the community member.
And I don't know that the court definitively said whether or not you said that it was the prima facie case was not made on the basis of causal connection. I don't know that the court specifically said that there was not an issue of fact as to whether or not she actually contacted the auditor's office or whether it was reported. Would that be accurate?
There was some kind of back and forth about that between the parties. Again, we take the position that it was not, and that there is no evidence that she actually reached out to the state
court
office.
didn't necessarily definitively decide that way. The court just said there was no causal connection or whatever, according to you.
So the trial court actually looked at the whistleblower statute as far as whether she engaged in protected activity kind of under two sections of 4113.52. and ultimately found that under one, she couldn't be a whistleblower because she did not report to the state auditor, and under the other one, she was a whistleblower, is what the trial court found. But our position is that really she should receive no whistleblower protection because of this
I remember
timeline.
that now then, and so then she went on to the prima facie case then in regard to whether or not there's a causal connection.
That's correct.
Okay, let me ask you this too. What was in the record in regard to what supervision or authority she had to basically oversee the superintendent's office as to how many hours an employee worked?
I'm not sure that that was developed, and I will say I know that was, that Mr. Morrison made several points about that. That was actually not briefed by him until the reply brief to this court. So that was not something that was addressed either in his brief in opposition to our motion for summary judgment, nor was it in his primary brief to this court.
But he didn't move for summary judgment.
Correct. Going back to the timeline, kind of go back. So at that point, the board, gave this directive to continue to investigate. She presented kind of this spreadsheet as a result of that report. And then with that spreadsheet, the then president reported it to the state auditor. It was also separately reported to the police by a separate board member. So I do want to get into the pretext, the pretext piece of this as well, and the arguments that were raised by Mr. Morrison here today, as well as in his appellate brief. And I will say, if he cannot establish a causal connection, I do think there's some overlap in the facts between a causal connection and pretext, so I'm going to kind of discuss those together. But I want to be clear that certainly if she cannot establish a prima facie case, then the burden would not shift to the board to then establish a non-retaliatory reason. But because the trial court, made that kind of hypothetical argument, we will as well. So again, Stoicoiu's performance issues here, namely her failure to timely detect and address significant financial irregularities, which she herself admitted at her deposition were approved under her watch as treasurer. So again, when we shift back, Ms. Stoicoiu is required to establish pretext.
But isn't the fact that she wasn't disciplined for that enough to rebut or shift the burden there?
I'm sorry, can you repeat your question?
You're saying she didn't report something timely, and he's presenting evidence, the appellant's presenting evidence that a whole lot of things that she wasn't disciplined, and so do you think that the judge impermissibly weighed evidence here instead of saying reasonable minds could only come to one conclusion?
I don't think so, Your Honor, no. So as an initial matter, as far as what her job duties were as a treasurer, it was absolutely her duty as treasurer to monitor the spending of the school district and ensure that improper spending was not occurring. She testified to the same during her deposition. As far as discipline goes and the fact that she was disciplined and by the non-renewal and others such as the former superintendent were not disciplined, that's just simply not true. As you mentioned, she was non-renewed. That was an option that the board district, per statute, is permitted to take at the conclusion of one's contract. So they made the decision to do that, simply to vote to non-renew her. The former superintendent and this other administrative assistant that were alluded to, they were required to make the payments back, those public fund payments back based on the state auditor's special investigation report. And the superintendent, the former superintendent at this point, his contract was simply not up for review or renewal at the same time as Ms. Stoicoiu's was.
But nonetheless, at the time that they non-renewed her contract, they did not discipline the superintendent or the administrative assistant.
No formal discipline, no. But Ms. Stoicoiu also was not disciplined. As far as any evaluation.
And what was the record pertaining to when was the superintendent ever non-renewed?
I don't believe so, Your Honor.
Okay, so the evidence was that the superintendent intentionally misspent public funds, and he was not non-renewed. His contract was kept, no discipline was issued. But the person that reported it, she was non-renewed. Doesn't that sound pretextual?
I don't believe so, Your Honor.
So negligence causes you not to be renewed, but intentional conduct, you can still stay.
The treasurer's office, at the end of the day, these expenditures were reviewed by her and presented to the board. So the board, it was within their prerogative to make the decision to non-renew her based on those performance issues, based on the fact that she was not keeping a close enough eye on the expenditures that were happening. I think Ms. Stoicoiu and the former superintendent need to be kept separately here for purposes of a whistleblower retaliation claim. Not only is she not a whistleblower, but it was the board's prerogative to take this decision at the time that they were able to non-renew her. Her contract was up at that point.
But doesn't that go to pretext, I guess is my point? Because if a person who you report is doing something improperly, they are not disciplined or have any adverse employment action, but the person that reported them does have that. Isn't that evidence, or can't that be evidence of pretext?
And if you answer, I'll let you know about a minute time left. That's okay.
Thank you, Your Honor. No, I really don't believe so, because this is within her job duties, and she was not the person.
I'm sorry, go ahead, you're talking.
I apologize. She was not the person that identified these issues. She's not, I think that's like the most important piece here. She was not the person that identified these issues. It was initially this Mr. Hunt, and then when the board received this information, they were the ones that gave her the directive to continue to investigate. So, okay, they were not trying to hide or like do anything, kind of nefarious to cover up, what was being done here. They wanted a resolution. They were suggesting to her to do these things in her role as treasurer so that they can come to a solution.
Okay, I need to interrupt you though right now, because what I want to ask you then is, so you see the critical differences that she did not find it and report it. She only reported it from another source.
No.
So, no what?
I don't think that's the only reason.
Oh, I said critical.
Oh, yes, I think that is a critical component of this analysis, yes.
Do you have any follow-up?
No.
I see that your time is up if you would briefly conclude.
Absolutely, thank you, Your Honors. Based on all of the foregoing, the board respectfully requests that this court affirm the order and judgment of the Summit County Court of Common Pleas. Thank you very much.
I would like to address three things to begin with. I want to ask about the state statute. That issue was never raised in the trial court, and that would be a burden on the appellate, and they have raised that argument in front of this court. Relative to a prima facie case, you hit the nail on the head, Your Honor. First, this report illegal conduct. Was there an adverse employment? Did he suffer damages? It's only after you get to those three, which is a prima facie case, that then the appellate has to demonstrate a legitimate business reason. Then the burden shifts back. Contrary to what counsel said, the trial court, in its original summary judgment, concluded there was a prima facie case. Here, in order to reach into the legitimate business interest or pretext, you must first find a prima facie case. And the trial court did that again and said that the appellate lifeline failed to establish pretext. So I believe, number one, there was a prima facie case found by the trial court, and the only reason we're here is on the issue of pretext. Now, counsel informed the court that the superintendent and the employee had to pay the money back. But what she didn't tell you, is both of them got raises in order to allow them to pay it back over time. Here, they would have you believe that my client's conduct was egregious, and for that reason, they non-renewed her. However, the person who developed the scheme, the person who took the money, the board members who took it was his, no fault, no discipline. There's only one question in each of your minds, and that is, how can that be right? And it's not right. And I would ask the court to remand this to the trial court for a full trial on the matter. Thank you.
Thank you. The court will take the matter under advisement and issue a decision in due course. When that decision is made and released, it will be mailed to you by the Summit County Clerk of Court and will also be available on the High Supreme Court website. With that, on behalf of the court, I'd like to thank both of you for your presentations this morning.